So, Tom,
unless
before you dig into that, did we explain sort of how there are two laws that could apply here?
Oh my God,
that's what AJ just did.
That's really what I just did.
Literally, that's what he did.
Literally what I just did.
Is that literally what AJ just did?
Yes. Not only does Ruchit not listen to the show, he doesn't even listen to the show while he's recording it.
All right. Should we start the show?
I thought we started the show.
Oh my God, Ruch. If you listen to the show, you would understand when the show starts.
Dude, I listen to the show every now and then now.
That's a lie.
No, it's not. It's true.
That's fake news.
Dude, it's not fake. This wasn't reported on CNN, okay, Tom? This is like right here on our podcast. We would not put fake news on our podcast. Although AJ did almost put some fake news on the podcast. You remember that last week?
It didn't make it through the edit.
Thank goodness. Thank goodness.
And it wasn't fake news. It was real news, just from a fake source. No, it was accurate. It was like corroborated by CNN in almost identical terms.
I don't think so.
Yeah, I'm curious now. I'm curious because I had come away with the impression that I had reported accurate news and I just had a bad link.
No, dude. No. Like that was like a very It was propaganda, right? So, you know, the definition of propaganda is like you string a bunch of facts together that are independently true, or independently have some truth to them, and then but you leave an impression that is like completely false.
So what was the false impression?
I don't even remember the news right now, dude. I forgot about it.
All right. Do we want to do this New York Times Nazi story?
I don't think we have any very contradictory opinions on this issue, do we? Like, I think we're all in agreement.
Yeah, I mean, I think we are all in agreement, but maybe we should just talk about it for a moment for our listeners. I mean, so I'm kind of torn on...
I think it's kind of boring when we're all in agreement.
Tom, I disagree with you about that.
Okay, well, let's talk about that. We can have a meta conversation.
Oh my gosh, no. So one thing that I thought, I kind of like struggle with whether we should even tell our listeners about this story because, you know, are we, again, this is the meta conversation, I guess. Like, should we actually even be like encouraging people to talk about such things? But maybe we should. So the New York Times put out a story this weekend about a Nazi living in Ohio. And the story is really, I think, pretty bad journalism because it leaves you with the impression, it focuses on sort of like the fact that this particular Nazi has a wedding registry, that he goes to Applebee's, that he seems otherwise normal other than the fact that, you know, he's a white supremacist and thinks Adolf Hitler's, that Adolf Hitler was pretty chill about a lot of things, were his words, not ours, obviously.
I think the greatest offense that they made is that they infringed upon our copyright.
Yes.
America's Heartland.
That's true. They said the headline, what's the headline, Tom?
The headline is A Voice of Hate in America's Heartland.
It triggered my Google alert. I had a Google alert for our podcast and it triggered our Google alert. I was very frustrated.
That's true. I think we should sue them for libel. For trying to make it seem like we have a bunch of hate, which we don't. Damn it. I don't know why they did this. Like, why did they use our trademarks?
As an aside, does this guy look like Ben Affleck to you, or is it Casey Affleck?
No,
Tom, you're normalizing him.
He's just another guy that goes to Applebee's that because he's white, in Tom's eyes, he looks like Ben Affleck.
Casey Affleck.
Why is Tom normalizing Casey Affleck, who is not normal? It is not acceptable in our society. Why is Tom normalizing Casey Affleck by suggesting that he looks similarly to your ordinary Midwestern, corn-fed white supremacist?
Another thing that I noticed that was kind of hilarious about this is it looks like some of these photos have been Instagrammed. Did you guys get the sense that like these photos were Instagrammed? Like, especially the photo of the guy's bookshelf, you know? I don't have the books that this guy has, but I've definitely taken photos of my bookshelf. There I go, normalizing again.
Isn't the New York Times that did that?
Yeah, dude. But we're talking about it. You're comparing him to... You know, he kind of does look like Casey Affleck. You're right.
Rooch is normalizing Tom's comparison to Casey Affleck. So basically we're in consensus this New York Times profile is trash.
Yeah.
Yeah.
I just don't know why they... I don't know why they did this, number one. And then I think there's this... There seems to be an obsession with sort of trying to understand white supremacists, and it's almost like it's our new obsession. You know what I mean? It's like everybody wants to be that guy that wrote the book about the hillbilly elegy book. You know, like everybody wants to sort of everybody wants to try and understand like this segment of America. Now, he didn't write about white supremacists, right? Obviously, I don't want to make it sound like that's all of middle America. It's obviously not even close. Hopefully this will go away, this entire story, and like we won't talk about it. But I also feel like when you write about a white supremacist in this like very normal way, you know, on a recent weekday evening, Mr. Hoveter was at home sautéing minced garlic with chili flakes and waiting for his pasta to boil. The Cates were wandering in and out of their tidy rental house. Books about Mussolini and Hitler share a shelf space with a stack of Nintendo Wii games. The pasta was ready.
So let me ask you this. Okay, so I think we're all in agreement that you know, this is a step towards normalizing the Nazi. It's bad, blah blah. Let's see what the other side of the argument is, because I think the two sort of most persuasive arguments I've heard as to why this is something is necessary are sort of all along the same line. One is that, you know, it's a reflection of, you know, what Nazis are already normalized. That is that, you know, they are, you know, people that live next door to you, that look just like you or I, that hold these, you know, beliefs in their head. Right. So like that's the first. The other is that, you know, what makes people uncomfortable about this article is not the, you know, the way it discusses the Nazis. It's that it is a reflection of that fact that these people are just normal people that you could live right next door to you, you know, and that scares a lot of people, and that's what's causing the reaction. What do you guys have to say about? And I think I'm fairly encapsulating those criticisms, but if I'm not, you know,
no, I think you are.
Town.
I think you are.
What do you guys have to say about that?
I think it's just, I guess, not particularly newsworthy or important. The fact that these people live next door is maybe, you know, is important and something that, you know, you'd want to know. The fact that they live like normal lives, you could just say that, right? You don't have to, like, when you're, as a journalist or as a storyteller, you choose what image to portray. So you can say that these people seem otherwise normal, but they hold these like terrible views, and then go to describe like what their terrible views are, right? And, you know, these are like, the guy is a Nazi. Like, we don't need a debate on like whether that's terrible or not, although he seems to think that's a debatable thing. But we don't need to, just because we don't need to paint the picture of this is a normal person who just wants to live the American dream. Because honestly, you read this article and you take out the handful of references to the fact that this guy's a Nazi, and you think they're just profiling some random dude that wants to live the American dream. You know, the article ends with, they talk about buying a new house and their plans for the future and having kids. The fact that this guy's normal is not really news. You know what I mean? And it's not really like, it doesn't teach us anything, I guess is what I would say. I appreciate what they're saying, that they might want to make people aware that there, you know, are people like this, and, you know, they seem pretty normal. And, but they didn't think about the consequences of a paper like the New York Times making Nazis appear normal. And that's the thing, right? Is that, like, it's as with reality TV. You can make someone appear batshit crazy, or you can make them appear normal, right? and it just depends on how you tell the story. So what's the most important thing about this guy is, I guess, the question. Is it his Nazi views, or is it the fact that he goes to Olive Garden a couple times a week?
Mm-hmm.
Or that he has a wedding registry? That's probably not the most important thing about this person.
Yeah. I think that's right. And Nazis are bad, right? Like consensus?
Yeah, consensus.
Okay. Consumer Finance Protection Bureau.
What about it?
Yeah, what is the CFPB, AJ? You want to somebody want to take a stab at what this Consumer Finance Protection Bureau is?
I'll cut you a deal. Tell you what. I will do the work of describing for the listeners what the CFPB is, if you can tell me who the acting director is.
Done. Easy. The acting director is whoever brings me donuts.
It's true.
Okay, so the Consumer Finance Protection Bureau is an administrative agency in the federal government. It is part of the Federal Reserve System, and it was created by the Dodd-Frank bill. A lot of you will remember the Dodd-Frank bill as the act that created a series of consumer protections and strengthened the finance industry in the wake of the 2008 collapse. So what is the CFPB? The CFPB is the brainchild of Senator Elizabeth Warren, and it enforces consumer protection laws in finance and banking. So, you know, the sort of things that it might be looking at is, insufficient fund fees on like bounce checks and things like that, or fees on your credit cards, anything that is sort of hostile to consumers or is done in a way that it isn't consistent with how you imagine consumer protection rules should work. You know, they will investigate and they'll create rules for enforcing. Okay, so AJ, why do we need, like, I mean, I thought, like, one of the things that I think the articles this week didn't do a very good job of is sort of saying, like, why do we need a Consumer Finance Protection Bureau, right? Like, why does it, you know? That's a good point. So in sort of shepherding the creation of this agency is genuinely Elizabeth Warren's brainchild. I think she had been advocating for an agency like this since before she was a senator. And the point is that there are a lot of different entities that regulate the banking industry. There's the FDIC, there's the Federal Reserve, there's the Department of the Treasury, etc. The Attorney General's office, right? Okay, so there wasn't really one clearinghouse agency to coordinate the investigation of issues in the banking industry, and there wasn't really. It was nobody's job to collect all of the various consumer protection regulations existing in all of these sprawling agencies. And also, I think it's fair to say that there was no single agency whose core mission was consumer protection, right? So, like, the point of the Federal Reserve System is to ensure maximum employment and low inflation, or at least stable inflation is more accurate, right? And the point of the Department of the Treasury is whatever the Treasury does, right? But there's no agency whose core mission is consumer protection.
But wouldn't conservatives say that, you know, why does there need to be an agency that is a federal agency that's core mission is consumer protection? Why not leave that to the states?
I would say, I mean, here's my answer to that. I would say that consumer protection is sort of a national affair, right? Which is that, you know, most commerce is interstate commerce, especially in something like banking, you know, where a lot of the bad behavior is happening across state lines, for one thing. Secondly, states have a pretty uneven record of actually prioritizing consumers, you know, in terms of like actually enforcing laws that protect consumers. So, I mean, those would be my major sort of policy arguments for it.
So the Consumer Financial Protection Bureau. So that's what it is. That's what it is. That's what it does. It's good. Everybody agrees that it's good universally in the whole country.
Well,
everyone likes it and thinks it's great.
Not everybody, really.
Not everyone thinks it's great. Okay, well, that's
not
a problem.
everybody.
I think there's like a big portion of the conservatives who believe that the Consumer Finance Protection Bureau is unconstitutional. Does anybody know why?
Well, let's before you go to that, AJ, I actually want to like split up this argument, because I think if our listeners are out there, you know, being listeners, listening to our podcast, and maybe even listening to other people, you they're going to hear a lot of bullshit. Okay, not from us, obviously, but one of the things that they're going to hear is this idea that the reason conservatives and Republicans primarily hate the CFPB is because it's unconstitutional, right? Now, they may indeed think that it's unconstitutional. They may or may not be right, but that's not why they hate it, right? They don't like the policies that the CFPB promulgates. And they don't that's really what it is. And so I think I want our listeners to take away the idea that it's not some sort of, as is often the case, it's not some vague sort of constitutionality issue or some, vague due process issue or any of these other, they're hiding behind legalese. And the legalese does matter. And we're going to go into the legalese like a little bit later in the show. But they don't like the policies. And if I can be just a little bit cynical, I think the reason they don't like the policies is because their donors don't like the policies. The big banks don't like. I mean, I'm going to find the specific citation for you, Tom. But, when the CFPB and Dodd-Frank, in kind of working Dodd-Frank, the legislation, working in concert, basically forced banks to stop charging overdraft fees, that was tens of billions of dollars in profits that the banks no longer got to make because they couldn't charge the consumer a $35 overdraft fee. So all of these $35 adds up to like tremendous sums of money. And you have a regulatory agency that says, listen, that's abusive. And if you're a bank, you don't get to do that anymore.
All right. So let's put to the side whether the CFPB is constitutional. Let's make this an edit point because I want to get back to that. Let's get into the actual news of the day. So the news of the day is that the director of the CFPB, Director Cordray, who was confirmed in 2013 by the Senate, stepped down effective November 24th. I think his plan is to run for governor of Ohio, but that's not that important. Okay, so the directorship of the CFPB is vacant. And the question is, who is the acting director of the CFPB? And there are two people who have fairly legitimate claims to be the acting director of the CFPB. The first is Mick Mulvaney, who is a former congressman. He's the head of the Office of Management and Budget. He was confirmed by the Senate to be Trump's nominee to be the director of the Office of Management and Budget. And the other option,
or as some lawsuits would call him, a White House staffer.
Yeah, we'll get to that. Okay, the other person who claims to be acting director of the CFPB is Leandra English, who was the chief of staff to Director Cordray. And on Director Cordray's last, I think like the second to last day or the last day that he was in office, he appointed Leandra English as his deputy director. And their theory is that as deputy director, she's the acting director when the directorship is vacant. Okay, so the two laws that we need to look at to decide who is the acting director is the two laws are, first, Dodd-Frank, and the second is something called the Federal Vacancy Reform Act. And the Federal Vacancy Reform Act was adopted in 1998, and Dodd-Frank was adopted in 2010. And they have provisions that appear to conflict with respect to what to do in the vacancy of this agency. So, first, the Federal Vacancy Reform Act says that for certain agencies, specifically executive agencies that are not headed by multi-member commissions and et cetera, when there is a vacancy in a Senate-confirmed job, the president has the authority to appoint someone to be acting office holder and to execute the functions of that office, as long as that person has been confirmed by the Senate for some other job. So as we have here, Trump said Mick Mulvaney was confirmed by the Senate to be the director of the Office of Management and Budget, and CFPB is an executive agency to which the FVRA applies, and so Mick Mulvaney can be acting director. The other law that you need to look at is Dodd-Frank. And here's what Dodd-Frank says. Dodd-Frank says that in the absence or the unavailability of the director, that the deputy director shall execute the functions of the director's office. And it also says that the director has the unilateral authority to appoint the deputy director without any need for consent of the Senate or of the president.
Does that second point really matter to the issue?
I think that let's say you were like really on the edge. You read one brief and you read the next brief and you're the judge and you like, you're looking at it from this sort of like Judge Posner perspective, right? Like you work backwards from some reasonable outcome and you try to imagine there's support for it in the law. If you're trying to imagine what the reasonable outcome is, and on the one hand, you've got Mick Mulvaney, who has already been confirmed by the Senate to a job that some may view as more important than the CFPB directorship. On the other hand, you have the former director's chief of staff, who has never been confirmed by the Senate for anything. I think that's like sort of salient from a policy perspective, right? I think it's like one of those pertinent facts. Maybe bad facts make bad law, but I do think it's like pertinent to someone who's like really on the edge about what to do.
Yeah, it does seem to make some intuitive sense.
I guess, to boil down to the conflict, so the Vacancies Act says that it's the exclusive means for determining who's the director, unless there is another statutory provision that expressly designates an officer or employee to perform the functions of the temporary director, right? And we have that unless in the form of the Dodd-Frank bill, which says that the deputy director shall serve as acting director in the absence or unavailability of the director. And so the entire question is which law controls. Does the Vacancies Act, which says that it's the exclusive means for determining who's the director, control, or does that unless in the Vacancies Act throw you out of the Vacancies Act altogether and allow the Dodd-Frank bill to determine who's the director? Or does that unless just mean, look, the Vacancies Act is no longer the exclusive means. There can be multiple ways of determining or establishing a temporary director, including the Vacancies Act.
Right. I think a much simpler way of distilling the question is the FVRA says that it's the exclusive means unless certain conditions are met. And I think it's unambiguous that the Dodd-Frank bill meets the unless clause. And so the actual central question is, what is the effect of satisfying the unless clause? Is if you satisfy the unless clause, does the FVRA not apply at all? So the FVRA is no longer a means of appointing an acting director. Or in the alternative, when the unless clause is met, does that just mean that the FVRA continues to apply but is no longer the exclusive means of appointing an acting director? Now, there actually are a lot.
I don't really understand this. I have to be honest. In my understanding of it, it just seems like plain English. It applies unless one of these conditions are met, and in this case, it seems clearly that condition is met.
So if it just said the FVRA applies unless these conditions are met, that would be one thing. But what the FVRA says is the FVRA says it applies to all executive agencies, and the CFPB is definitely an executive agency. And then it says the FVRA is the exclusive means for temporarily authorizing an acting official unless certain conditions are met. And so what does the unless clause negate? Does the unless clause negate the entire application of the FVRA? Or does the unless clause just negate the FVRA being the exclusive means?
Why does it matter?
Well,
because one determines the...
one determines... So if the unless clause negates the entire application of the FVRA, if the FVRA does not apply to the CFPB because Dodd-Frank satisfies the unless clause, right? Okay. Then Mick Mulvaney, the president has no authority to appoint Mick Mulvaney as acting director.
Okay.
If the unless clause only negates the exclusive nature of the FVRA, so the FVRA applies to the CFPB and Dodd-Frank also applies to the CFPB. Now you got a real question, because there are two separate statutory authorities to select the acting director, and the two statutory authorities, that neither of which is the exclusive means, has each points to a different person. And so if FVRA applies to the CFPB, it is not clear to me who the acting director is, because
Let me ask you a question, and I think this might be a way of analyzing the statute. So the statute says, this is the exclusive means unless this condition is met, right?
Yeah.
Let's say you believe that what that means is that it negates the Vacancies Act altogether, and the unless clause means that you have to go to Dodd-Frank and Trump loses, right?
Yeah.
Let's say that's what you believe. How would you write the Vacancies Act differently if you wanted the opposite conclusion?
Wait, ask the question one more time.
Yeah. So Vacancies Act says, the Vacancies Act applies, or the Vacancies Act is the exclusive means unless some other provisions apply. How would you write that if what you were trying to do was let Trump win? That is, let both the Vacancies Act and Dodd-Frank be these different ways of appointing a temporary director.
Okay, so you would say the FVRA is the exclusive means for temporary authorizing an acting official to perform the functions of the office. Then you would have the unless clause, unless another statutory provision designates an officer. And then you would say that that officer designated by that other statutory provision shall serve until the president exercises his authority or her authority under the FVRA. I mean, I think that is the way you should write that. That is the way the bill should have been written if Congress's intention is that Trump should have the ability to appoint Mick Mulvaney, and Mick Mulvaney would serve and not acting, Deputy Director English. So there are a lot of folks that have weighed in on this. The Office of Legal Counsel, which is part of the White House, Don McGahn, who was the Trump campaign lawyer, is now the legal counsel to the president. And the Office of Legal Counsel put out a memo saying that the Office of Legal Counsel thinks that the unless clause only negates the exclusive nature. And then it sort of hand waves away what to do about the conflict between, let's say FVRA is non-exclusive, and so Dodd-Frank applies and FVRA applies. The memo sort of hand waves away what to do about the conflict of laws and just says Mick Mulvaney's the director. The General Counsel of the Consumer Financial Protection Bureau has also issued a memo, which sort of reads to me as though she had read the OLC memo, the Office of Legal Counsel memo, and then just summarized what she. I kind of think that Office of Legal Counsel forwarded her their work, and then she summarized the memo.
I thought her memo said, or either her memo or a news article that I read, I believe said that she said that the analysis in the OLC memo appears to be correct. Period. As in reference to that.
Okay, and then finally, probably the most persuasive authority to weigh in is that in 2016, the Ninth Circuit Court of Appeals had a case called Hooks v. Kitsap Tenant Support Services. And in that case, the Ninth Circuit said that when the unless clause is met, the FVRA still applies, but is just the non-exclusive source of authority for appointing an acting director.
Why is that so persuasive? I mean, the Ninth Circuit is one of the most reversed courts in the land, right?
But they haven't been reversed on this, Tom.
That's true. They haven't been reversed on this.
I mean, I think the Ninth Circuit opinion also sort of hand waves away what to do about the conflict of laws and just says, thus the president is permitted to elect between these two statutory alternatives to designate an acting general counsel. But I actually think that and we'll get to whether this is constitutional or not. But the point of the CFPB is that it is specifically an independent agency, right? So the director of the CFPB can only be fired by the president for cause, which is a departure from lots of other offices that the president can fire for any reason.
But that's not a complete departure from all other laws, right? Like the what is it? The Federal Reserve that works a similar way, right?
So the point is that the CFPB is supposed to be an independent agency, and so saying that the president just chooses between these two statutory alternatives to a certain extent defeats the purpose of the congressional intent with respect to having the CFPB be an independent agency. Now, full disclosure, the Ninth Circuit opinion and the Office of Legal Counsel memo both cite some fairly persuasive excerpts from the legislative history of the FVRA that does sort of seem to indicate that Congress thought that it would just be non-exclusive if the unless clause is met. And I haven't dug that much into the Senate legislative record to sort of see if that is accurate or not. But anyway, full disclosure, I haven't read that. So, but I think an important thing to keep in mind is that the text of the actual text of the law trumps any sort of secondary evidence, like, you know, the record of the Senate Journal or whatever. So, you know, a lot of fairly persuasive folks have weighed in and said that Mick Mulvaney will be the acting director of the CFPB.
So let me talk about something that I mentioned in the Slack, which is that no one has written or seems to care about the poor IT guy. Okay? There's an IT guy at the CFPB right now that's having conflicting orders. You know, acting director English is emailing him and being like, don't you dare give Mick Mulvaney email access. Like, lock out Mick Mulvaney's computer, you know? And Mick Mulvaney is probably like calling this IT guy and saying, you know, Director English, or, you know, not acting Director English is no longer here. You know, I have a donut for you. Please, you know, and coffee, please turn off her email. So what is this poor IT guy supposed to do? No one seems to care about what this poor guy's going through. Are you an IT guy at the CFPB? If so, reach out to us. Tweet at us. You know? And let us know. We'd love to interview you to understand how you're handling this situation where you have two different directors and they're telling you completely different things. Also, how hard is cybersecurity at the CFPB? Like, are you constantly getting hacked? Do people even care to hack the CFPB? You know? Anyway, nobody cares about this poor guy. And I want him to know, if he's listening to our show, that I care. And that this is very confusing. This is like not fun for people that work at the CFPB, I'm sure. They've got these two bosses, you know, they don't know whose orders to obey. And thankfully there's a lawsuit. You know, you never say that really, I guess, but thankfully there is one in this situation.
And this is the lawsuit in which Mick Mulvaney is named as a White House staffer.
The lawsuit is actually really funny, I found. You know,
I wish they had named him like White House intern.
Oh, so have we told everyone about the lawsuit? So Leandra English has sued. She hired Deepak Gupta to sue.
Who's my uncle? Actually,
no,
that's not true.
Okay,
my uncle's name is Deepak Patel, but in any event.
Well, okay. So she hired Deepak Gupta to sue the CFPB in federal court, and she wants a federal judge to say that she is the acting director and that Mick Mulvaney is not the acting director.
And to order the IT guy to deactivate Mick Mulvaney. No, that's not in there. I'm kidding. If you're Deepak Gupta and you're listening to this podcast, we want to interview you as much, or almost as much at least, as we want to interview the IT guy to get your side of the story. Don't you guys agree? Shouldn't we interview Deepak Gupta if he's willing to be interviewed by us?
Deepak, come on our show.
Tom, you don't seem very excited about interviewing Deepak Gupta. Like, if I'm Deepak Gupta and I'm listening to this show, I'm probably not responding because of Tom's complete lack of excitement.
I'm writing show notes. I'm looking up his firm profile.
Do we have a American Heartland email address yet?
Yeah, we've had it since day one.
Oh, cool. Can we email him?
If you want. His email is deepak@guptawessler.com.
Oh, he's got his own firm. Dude, that's pretty fancy. His parents must be proud.
Anyway, okay, so that's the state of things. I mean, what do you think?
You know, I don't know. I think it's a pretty close case, but I everything that I have read so far makes me think that it's going to end up as a Trump win, and that I think the courts are going to treat it as two non-exclusive, you know, or that the Vacancies Act becomes non-exclusive if another act applies, but that doesn't mean the Vacancies Act does not apply, right? And in terms of the conflict, I think what the court is going to do is similar to what, you know, the Ninth Circuit did, is just say, well, you know, the president can choose to appoint under the Vacancies Act if he so desires or not.
The problem is that like Dodd-Frank is unequivocal, right? Dodd-Frank shows that Congress wrote in unequivocal language, the deputy director acts as the director when the director is unavailable or absent. And the idea that Congress wrote in unequivocal language that the deputy director is the acting director, by writing that language that Congress actually intended to write, is that the deputy director is acting director until the president appoints someone. I think that, like, to read.
My response to that, it would be that if Congress didn't unequivocally write that, then we wouldn't even have this issue, right? Because you can only leave the realm of the Vacancies Act unless the statutory provision expressly designates an officer or employee to perform these temporary functions, right? So it wouldn't even, there would be no conflict, right, if that weren't the case. Only if Congress had, expressly and unequivocally writes, that so-and-so it can be an acting director, will that unless clause even apply?
It just seems to me that it's a really bizarre interpretation of the statute to say that when Congress writes the deputy director is the acting director, what Congress really means is that the deputy director is the acting director until the president appoints someone. Keeping in mind that this is supposed to be an independent agency that is outside of the president's authority, that the president can only fire a director for cause, et cetera, et cetera.
Well, I mean, you say that, but that's in essence what the word temporary means, right?
Well, what Dodd-Frank says is basically like, when there is no director, the deputy director is the acting director. So ostensibly, when the president nominates and has confirmed by the Senate a new director, then obviously there's no need for an acting director because the director is no longer vacant or absent or unavailable, right?
Mm-hmm.
But until a nominee is confirmed by the Senate, right, what Dodd-Frank says in clear terms is that the deputy director is the director.
Well, serves as acting director.
Right.
In the absence of or unavailability of the director.
Right.
So this all happened very fast, right? So Cordray resigns, or right before he resigns, he names his chief of staff the deputy director. He resigns. She becomes, at least for a moment, until President Trump names someone, she becomes unquestionably the acting director. Like, right at that point, we could argue about whether or not that provision in the statute is constitutional, but for that split second, however long that lasted, whether it was a split second or like 3 hours or whatever, she is the acting director. Then couldn't it be that, like, the FVRA can kick in at any time that the president decides to act? So couldn't it be like, so, you could have seen a situation where she was the acting director for like a month or 2 months, but then the president woke up and he said, listen, I'm kind of tired of having her as the acting director. I really respect Congress. I just respect Congress so much. And I just want to use the FVRA to appoint someone that's actually been confirmed by the Senate. And now I'm doing that. And now she's no longer the acting director, because there is a replacement under the FVRA. And I'm naming this person until, the Senate can go ahead and confirm my permanent replacement, who, by the way, is, Ben Carson. So, like, isn't that like a legitimate interpretation of the law as well, where in that situation, this is just a hypothetical, but she's been acting director for like 2 or 3 months. The president doesn't lose his right to name an acting director. He just hasn't exercised it yet. And the moment that he does exercise it,
that is the view of the Ninth Circuit in the Hooks case. But it is plainly contrary to the plain language of Dodd-Frank. The plain language of Dodd-Frank says that the deputy director is the acting director, period. Right? You're saying, you have to look at the FVRA, and so she's the deputy director until the president appoints someone. But that's not, let's say that the Ninth Circuit is right, and the unless clause negates the exclusive nature of the FVRA, right? So now now the FVRA and Dodd-Frank both apply, right? It is entirely unclear to me why the FVRA trumps Dodd-Frank when Dodd-Frank clearly just states, no, it's this person in particular.
Well, I think you could just say that there's like sort of both are correct, I guess, is the interpretation that I would read, perhaps, is that the president can, it's sort of, unless the president exercises his authority, unless and until, right? It's almost like unless and until the president nominates and the Senate confirms a replacement, right? Because Dodd-Frank doesn't say anything about what happens when the Senate confirms a replacement, right?
The Constitution says what happens when right?
Well, hold on a second now. I mean, so this is where I could be completely wrong here, but
yeah, wait, what are you talking about? Dodd-Frank does say the director shall be appointed by the president and with the advice and consent of the Senate.
Right, but no, it does. I'm saying that, like, what if, does Dodd-Frank specify what happens to the acting deputy director if a new director is named and confirmed by the Senate? Like, does it explicitly say that?
It says serve as acting director in the absence or unavailability of the director.
Okay.
When there's a new director, he's no longer absent nor unavailable.
Yeah.
Well, so can't that new director come through the FVRA just as that new director could come through this through confirmation by the Senate?
No, because that's not a new director.
No.
That's an acting director.
Okay.
So the Constitution is very clear that the president fills vacancies, right? There is no need for Congress to write that the deputy director will be the director forever until what, the next election, or until she dies, or what, right? No. Like it is. There is no need for Dodd-Frank to say that the president gets to appoint the next director because the Constitution already says that, right? But it is not clear that Congress intended for Dodd-Frank to only apply until the FVRA clicks in. There's nothing in the text of the FVRA that says that, and there's nothing in the text of Dodd-Frank that says that.
It's an interesting legal question. I don't know. I mean, I know how I want it to come down from a policy perspective, which is that, I would rather Leandra English be the director of the CFPB than, Mick Mulvaney. But I don't know about the law. I tend to think that this one's going to come down in the president's favor. I mean, one thing that could happen, I think, is let's gameplay this out for just a second, which is, let's say that there has been a, director or potentially acting director, Leandra English, has filed a lawsuit against the Trump administration and against Mick Mulvaney, as we talked about earlier. So let's say the district court, grants her relief and issues an injunction, and says, okay, you are the acting deputy director. President Trump, the Dodd-Frank trumps the VRA in this situation. At that point, I assume what would happen is not only would the president appeal, but he would probably challenge the constitutionality of the CFPB, either in its entirety or the constitutionality of the single director or whatever else. I mean, this could be sort of an interesting way, if this is what you believe from a policy perspective, to get rid of the CFPB.
So that I think is a good segue. So there are a lot of folks that think that the CFPB, the Dodd-Frank creation of the CFPB is unconstitutional, and there are basically two key provisions in Dodd-Frank that seem fairly questionable. So first, the Judge Kavanaugh on the DC Circuit has said that the CFPB is unconstitutional because independent agencies have to be composed of a commission of multiple directors. It can't be composed of just one director with unilateral authority to run the agency.
Like, what's the reason for that distinction?
It's a great question. The reasoning is very poor. So here's basically the history. So in the Tenure of Office Act is an old law. The Tenure of Office Act was passed during Andrew Johnson's administration, and the purpose of the Tenure of Office Act was to goad Andrew Johnson into doing something impeachable, and then they would impeach him, and it worked. Andrew Johnson reorganized the cabinet in violation of the Tenure of Office Act, and he was impeached. So good job for Congress. They achieved their aims. During the Wilson administration, the Supreme Court looked at the Tenure of Office Act and said, whoa, no, the president has the authority to dismiss executive officers. It's an encroachment on the separation of powers for the president not to have this authority. And that was a case called Myers. Okay, so now you look at you fast forward to the New Deal, and in the New Deal, the Supreme Court created an exception to the Myers holding. What's the exception? Well, there are such things as independent agencies. And an independent agency is an agency that is set up for some particular purpose that Congress has a good reason for wanting to be independent from the influence of the president. And the people who run the independent agency, Congress can say that those people can only be removed by the president for cause. And that is a case called Humphrey's Executor. So the Supreme Court precedent is that the Congress can create, the Congress can't create a law that says, oh, the Secretary of War can only be removed for good cause. No. The Secretary of War, one, no longer exists, but two, the president can just remove for any reason. But independent agencies. So an example
that came quick. The Secretary of War, bam, gone.
Right. I mean, that office no longer exists. But if it did exist,
the audacity.
Wasn't it just converted to the Defense Department?
Yeah, it was, Tom.
Yeah,
but
that's true.
That's not as good for my story.
Okay.
You're totally screwing my story, Tom.
Okay. So an independent agency in all of the history of independent agencies, they've always been comprised of multi-member commissions. So an example is the Securities and Exchange Commission. It's a multi-member board. The Federal Reserve Board, a multi-member board, right? A lot of people think that the CFPB is unconstitutional because there's just a single director that promulgates rules, enforces those rules, makes all the decisions, right? There's no multi-member board. I think that this argument is totally bogus. I think there's no textual basis for it. I think that this is really sort of like dogmatic claptrap. But what do you think?
I don't understand this distinction. Like, I really don't know what the reason for this is. Like, why does a multi-member board not violate the president's authority? Or not violate sort of his powers under Article 1, or is it not Article 1, Article 2, sorry.
I think the idea is that a multi-member commission, requires some sort of consensus building in order to to carry out its functions. And so, for example, at the FCC, Ajit Pai needs 2 other votes to do whatever it is he needs to do. Right. Whereas the CFPB, Cordray could just go crazy, could get drunk and write an order that says that Bank of America is abolished. And then, what would you do? Right. Like, he doesn't need to go and get 2 other votes on his commission. He doesn't need to run it past anybody. I think this is a bogus argument. Right.
Well, so Congress has a lot of tools, right? Like, in order to check that. You know what I mean? Like, that's the other thing that I never understood. So this person has all kinds of authority and power, and people say that the CFPB, because it's run by one person, is lawless and has unlimited authority. I mean, first of all, that's not true. Like, Congress could change its authority at any given time. Number one. Number two, Congress has the what's that 1996 law, the Congressional Review Act, I believe is what it's called, which allows Congress within 180 days to, by simple majority, to overturn any rulemaking that promulgated by any agency, which the Republican Congress has been using. I mean, they've used it multiple times this year.
Yeah, so I agree with you. Right, I think this is totally claptrap, right? Like, I think this is applesauce. Kavanaugh is particularly noteworthy as an extreme right wing judge, and I think that most of his opinions are immediately circumspect. In these sort of areas where someone who is known for being a conservative justice, has this sort of departs so far from the text of any Supreme Court precedent or the text of the Constitution, and just sort of finds this principle in the ephemera of federalism and separation of powers, right? And he just says, "Oh, it stands to reason that a single director is unconstitutional." I think that for all of the for all of their complaining about like the court creating like a right to abortion out of thin air, like I think this is created more so out of thin air than say Roe v. Wade.
Yeah, I mean, I don't want to. I don't know enough about Kavanaugh to sort of criticize him as harshly as AJ just did, but this doesn't make a lot of it doesn't either from a policy or a legal perspective like make a lot of sense to me. Like either independent agencies are completely suspect and shouldn't exist and shouldn't be allowed, because they impinge on the authority of the executive, or, they exist and they're allowed, and it doesn't really matter whether it's 5 people on the board, 1 person on the board, or like 70 people on the board. It just doesn't really matter. I don't know how one is more or less respecting of the president's authority because they're independent in any event, right?
Okay, so there's one other consideration that may make the FVRA unconstitutional, and that is the fact that the director gets to appoint the deputy director unilaterally without requiring the assent of the president or Congress. So the Constitution says that the president shall have the power of appointment, and then there's a semicolon, and then it says, but Congress can permit the head of a department to designate the officer subordinate to the head of the department, right? So, for example, the attorney general, I think, is fairly clearly the head of a department. That department is the Department of Justice, and the way the Constitution reads, it would say the president has the power of appointment, but Congress could vest solely in the attorney general the ability to appoint certain deputy attorney generals, which is great. Okay, so is the FVRA a department? If the FVRA is a department, then the Constitution allows Congress to allow the director to the unilateral appointment power. If the FVRA is not a department, then the FVRA director can't have this power. So, question:
why wouldn't it be a department?
Well, why wouldn't it be a department?
I don't know. I mean, what is a? It seems like everything's a department, isn't it? I mean,
okay. Why wouldn't they be a head of the department?
Well, so there is some precedent on what departments may be. In Free Enterprise Fund, the Supreme Court said that the Public Company Accounting Oversight Board was a department, and the reason why is that it was not subordinate to any other branch of the executive agency, and it was a standalone agency. Right. So the Department of Justice is not subordinate to any other sort of executive agency, right? The department, right? But say the FBI is contained within the Department of Justice, right? So the FBI director reports to the Attorney General, and the FBI is part of the Department of Justice, right? FBI employees are employees of the Department of Justice.
So, I mean, but is the CFPB subordinate to any other agency?
Yeah, so Dodd-Frank says that the CFPB is an executive agency and is part of the Federal Reserve System. So it technically is part of the Federal Reserve, which is led by the Federal Reserve Board of Governors.
But it doesn't report to the Federal Reserve in any way.
Yes. So it is a standalone component of the Federal Reserve System. So whereas the FBI director reports to the Department of Justice, the director of the CFPB doesn't report to anyone.
Yeah, so like what? I mean, it seems like an existential question, but like, can you have an independent agency, or can you have a dependent agency if it doesn't depend on anything else?
Yeah, I don't know. I mean, I think that this is also like pretty kooky, right? I think it's like pretty clear that the CFPB director is a department, and I think the clearest indication that the CFPB is a department is that Congress thinks they're a department, right? So I think it's pretty clear that Congress thinks that the CFPB is a department. And the reason why is that under Article 2, Section 2, Clause 2, the power of appointing the deputy director can only be vested in the director of a department or the head of a department. And so Congress vested that power in the CFPB. And so I think Congress thinks that the CFPB is a department.
That's a little circular, but yeah, I don't know if... I feel like this Constitution, if this is the best constitutionality argument for the CFPB, I think it's pretty weak.
So here's a going back to the department issue. So one of the things we were talking about a second ago is it really within the Federal Reserve in any meaningful way? So one way is, as I understand it, the CFPB's funding comes from the Federal Reserve. So even though the CFPB director does not report to the Federal Reserve, to the head of the Federal Reserve, their money comes from there. Does that matter?
I mean, I don't think so.
Can the Federal Reserve pull the purse strings on them?
I don't know the answer to that, to be honest. But
so one thing to keep in mind is that in Free Enterprise Fund, the court said that the PCAOB is a department because it is not part of any other section of the government. But the Supreme Court didn't say, if let's say the Supreme Court had said the PCAOB would not be a department if it were part of the Federal Reserve System, right? That would be one thing. The court didn't say that, right? The court said, well, this thing is not contained in another department, and so therefore it's a department. It didn't say that anything contained in another department isn't a department. You know what I mean? It's like two separate things. All right. Do you want...
Okay.
So anyway, so what's our prediction? My prediction is Trump's going to win.
Yeah, same, I guess. Well,
what do you think? Sidebars?
My sidebar is actually a request of our audience, someone who is more science inclined than I am, because the BMJ published a study that basically found that drinking coffee is more likely to benefit your health than harm it for a range of health outcomes. And so what I want to know is if this is a valid study or not, if there's something wrong with the way that it was constructed or the methodology it used. Because I like coffee and I like drinking coffee, and I'd like to know if it's truly more likely to benefit my health than harm it.
Tom, are you giving our audience homework?
Basically.
Okay, cool. Dude, mine is this house in British Columbia, dude. Like, this is a $10 million house. If anybody around here has 1,000 Bitcoin that you don't need or don't really want, could you buy me this house? Like, if you're in our audience, you know?
Rich,
and
wouldn't you rather have like a $5 million house and $5 million of cash?
No, dude, this house is amazing. I want this house. Because, like, I can, I don't have, like, $5 million in cash, but, like, if I had this house, I would just, like, work remotely. You know what I mean? And if I couldn't work remotely, I'd probably just, like, I don't know, I'd do doc review or something. I don't know. No, probably not. I wouldn't do doc review. But, this is a nice house, dude. Have you seen the house? Have you looked at the pictures yet? I'm kind of hesitant to, like, make this be my sidebar because, like, what if one of our listeners sees this house and they're like, wow, that's a great house. Thanks, Richard. I found the house.
It's too
You know
late.
what I mean?
It's your sidebar. You already said it in the show.
It's like, what if, like, man, oh, damn it. Anyway, it looks beautiful. It's 10,000 square feet. It's right on the water. You get to see migrating whales, local fishermen. I really want to go to British Columbia.
All right.
I mean, actually that's not, I mean, we've been to British Columbia, Tom, but I mean, like, to go to, like, Victoria Island. Victoria Island looks like paradise.
My sidebar is a follow-up on a previous sidebar. I think we all remember Miss Yeah, the greatest YouTube channel of all time. Miss Yeah is a YouTube channel. There's a woman in, I think she's in China, but I'm not 100% sure. Like, it could be like Taiwan, and I just don't want to I don't want to get into this mess. But anyway, she like works at an office.
AJ just got our podcast banned in China. And possibly Taiwan as well.
I don't want to wade into this mess. I don't want to tell you where she is. But she goes to work, and every YouTube video features her showing up at work, being bored, and then scrounging tools from around the office to like cook outrageous food. And this video, I've had Miss Yeah generally as a sidebar before, but I think in particular you should look at this video. I put it in the Slack because she makes tofu from scratch using like a office hot water heater, and then she makes outrageous food out of the tofu that she makes from scratch sitting at her desk. And this is like insane. Like she does better cooking sitting at her desk at work in China or Taiwan or Hong Kong or like whatever. Like she cooks better food like sitting at her desk than I make like in my home with my kitchen.
I mean, I just made some tofu today, not from scratch, and I have to say it was not good.
No, she like makes tofu. I'm like watching her pull the tofu skin off the top of the tofu.
I basically ate gruel today. I ate like cauliflower rice with tofu, and it had very little flavor. And you know why I did this? Just so that I would be on time to this show.
Oh, I ate my dinner sitting at my desk while we recorded.
Tom didn't eat at all. Tom hasn't eaten in days. He's been working on the show notes.
Yeah, dude, it's a tough life.
It's true.
Oh my god, she's like making tofu. I'm watching her make tofu. Did you guys click on this?
I can't. Yeah.
Ruchit's computer doesn't let him.
Do you have like NetNanny? Does NetNanny like block YouTube in your house? Does Stephanie like not let you watch YouTube?
No. She watches YouTube. It's just that I'm upstairs in my podcast room, and I'm not able to. My internet's not working. Like it's kind of working, but it's kind of not working. It's clearly working enough for us to record, but it's not actually like letting me go on the Slack. So, or use Google products.
Oh my god, she's carving a sculpture out of the tofu. Oh my god, she made a flower.
Oh wow. She like made tofu.
Right? Right? That's what I was trying to tell you. She like made tofu.
And now she's like crafting a sculpture out of it.
Oh my god. She made a sea anemone out of tofu.
Guys, that camera's still not going on sale.
What camera?
The Fuji 100F.
Oh, dude, you should just get it. It's a good camera.
Is it? Do you think it's going to go on sale?
No, not for like 6 months or something. It's brand new and like really highly in demand.
It's a really good camera, dude.
Amazon keeps talking about how like, it's in demand and it's not gonna, they're not gonna have it.
Like, dude, if you don't want to like spend that much money on a camera, you should just use your iPhone. Just stick with your iPhone.
But I have an iPhone 6, dude.
Yeah, the iPhones are good cameras, dude.
Yeah, but I feel like I should get a better camera. You know what I mean?
No. Here's the deal, okay? You stick with your iPhone, right? And just make sure there's a lot of light. Wherever you're shooting a picture, just make sure there's a lot of light, okay?
I mean, okay, but
here's a cheaper way to get better photos than buying a nice camera. Install some Philips Hues all over your house.
Stop.
No, this is actually good advice. No. This is actually really good advice. So,
oh my god.
So
dude.
no. So I replaced all the lights in my living room with LED bulbs, and it was like kind of expensive. But the bulbs at their brightest setting, like on the wall dimmer at the brightest setting, put out literally twice as much light as the old bulbs. And the reason why I know this is that I can get I get like an extra stop of exposure on my camera. Like I could set the shutter speed to be twice as fast. Like whereas I used to have to use like a 1/60 shutter speed, I can use like 1/120 and get the exact same exposures with the old light bulbs. It actually makes a huge difference.
But
there are cameras that like used to not
like,
work at my house, and now they work at my house.
But the bigger point is, like, instead of like, if you don't want to spend the money on a good camera, spend the money on good lighting. Like the brighter your house is, the more likely that you will have better, at least at nighttime, better indoor photos on your iPhone.
I think I'm gonna get a new camera, dude.
No, like I'm seriously not joking. So like we bought like a bunch of wooden blocks with like different numbers on it. So like one face of the block says like 6 months, and one face says 9 months, and one face says 2 months or whatever. And for the first year of Jonah's life, we took photos every month next to the block, with the corresponding face showing. And now we have like a whole photo album of like 1 month, 2 month, 3 month, 4 months, 6 months, whatever, right? For pictures of Jonah, and like the there's like a marked difference after I replaced all the light bulbs in the living room, because there were cameras.
Is it possible that Jonah's face just got sunnier?
No, I'm totally serious, right? Because
No.
I could get the exact same level of exposure with a narrow aperture or with a faster shutter speed, and that meant that the number of cameras I was able to use, right? Because I have like film cameras that only go to like f2.8 or whatever. But also like the photos I could capture at faster shutter speed so that I wouldn't have motion blur. It was like, you don't really think about like one stop of light being a huge difference, but it's literally 2x the light. Like when you, in camera terms, one stop is doubling the amount of light, right? So if you open the shutter for 30 seconds and then or for 1/30th of a second, and then you open the shutter for 1/15th of a second, right? Like the second time the shutter was open for half of the time and it captured half as much light. You know what I mean? Like literally twice the light.
I think you guys have convinced me to get the camera. You've convinced me to get the camera.
Oh, I've been trying to convince you to get the light bulbs.